Good afternoon, everybody. This is Omar Serrato with the Tilted Lawyer podcast. I just got done. Well, I just got done with a lot of things. But I just was listening to Ask Two Lawyers and their analysis of what they were doing. And that was my first time that I've ever been introduced to them. They're really sharp guys. I like them a lot. I think that some people were thinking I was criticizing them last night on my stream when I was talking about the 47.1 stuff. No, the only reason why I did that stream was because people were freaking out about the 47.1 thing, and I couldn't understand why. And everybody kept on saying, "Hey, Ask Two Lawyers said this and that." And then, but I've since listened to their videos. I agree with everything they said. I did my own video on it. But today, in the course of all of that, there's this lady. She's a YouTuber. Her channel is called Without a Crystal Ball. And she came up with what she thought was like this smoking gun theory that was going to get Blake Lively's case dismissed. Her theory was essentially, wait a minute. So this entire thing was supposedly done under this loan out corporation, this loan out LLC called Blake L LLC or whatever it was. And it wasn't actually signed under her name. Well, guess what? She shouldn't get 47.1 protections anyway. And you know what else? She doesn't get FEHA protection. She doesn't get Title VII protections. She doesn't get any of the SH protections out of California because she was an independent contractor. That argument is not, although very creative and very astute of her for doing the research and figuring all that out, it doesn't quite work here. And I'm going to explain all of the reasons why. I'm going to go over some cases where people have actually made that very argument and just didn't work out. Robert De Niro tried it once. There was this Marita case that happened. There was a lot of, especially in the entertainment world, they have ferreted out that, look, it's a pretty common thing where entertainers have loan out contracts and they contract with the movie studio and they have obligations that they're contractually bound by personally. But for tax purposes, mostly, they will pay the loan outs and the entertainer will get paid through their loan outs. And then everybody kind of just goes around. But so independent contractor, right? But California says, yeah, bullshit. They have a test where they ferret all of that out and they figure out what's employee versus independent contractor. And does it really matter? Not really. They still get the same protections. Did you guys think that there was going to be a scenario where you couldn't, because of a loophole, file a claim for sexual harassment protections in the state of California? You guys know better than that. You have to know better than that by now, at the very least. Anyway, I got a lot to get to. It's going to be a crazy show. Let's get started.
Whatever you might be going through and wherever you might be, this is Omar Serrato with the Tilted Lawyer podcast. I'm here to take your mind off of things. Yes, I'm an attorney. No, I'm not giving you legal advice. We're going to sit and talk like people, as these are the candid thoughts of one practicing attorney, and it's after hours. So have a seat. Feel free to have a drink and join me. Let's get started.
Okay, so essentially, as I was doing my live stream last night, a lot of you had just finished watching Without a Crystal Ball, and she was essentially stating in her video, and I did watch it, the following, that Lively signed through her loan out company. Now, look, there was a lot of contracts that were written. There was a lot of contracts that were not signed. But the entities that were involved or were implicated in those contracts were largely Blake Lively's loan out company. So Lively's agreement with It Ends With Us was made through Blake L Inc., I think is what it was called, Blake L Inc. or Blake Inc. That's her personal loan out corporation. It was not her specifically, the individual. And they're like, wait a minute. You can't just sign the contract as a loan out company and expect to have the same protections in California. Those are reserved for employees. Without a Crystal Ball states that her argument was that she's legally a contractor. She's not an employee. She shouldn't be protected by Title VII. But Title VII, similar to FEHA, similar to California law, has this test where look, you don't just get to call yourself an independent contractor. If you don't have any ability to control your own schedule, if you're basically under their direction, if all of the things fit that you're honestly an employee calling yourself an independent contractor, then not only for tax purposes are you going to be treated like an employee, but the law is going to protect you like you are an employee. Title VII is not in federal law. Title VII would be federal law. It's not as lenient as California law. California straight up says, yeah, we're going to protect independent contractors too. And there's these very broad sweeping provisions about why they say that is. But Without a Crystal Ball says she shouldn't be protected by Title VII, that her rights to sue under the California's Fair Employment and Housing Act are limited, if not non-existent. She likely cannot bring a traditional employee harassment or retaliation claim unless it's properly linked to Blakel Inc. And my response to that, the short answer is, yeah, she can. She can. I think I kind of sort of addressed that question directly yesterday on my 47.1 stream. As what about she contracted under a loan out company? It's like, it doesn't fucking matter, is what I said. And it was later in the stream. I didn't get into too much detail about it, but my general takeaway was it doesn't matter. I saw Ask Two Lawyers address kind of that same question. It's like, yeah, but they still kind of, it was a good try, but not really. It's not going to work. That's kind of my thought too. Without a Crystal Ball, she mentions that the 17-point protections for return protection agreements, she was making this argument that Lively's legal team has portrayed that document as if it was a safety measure that was supposed to be for protection of the entire cast and crew. And then she pointed out the fact that that agreement didn't happen until certain other things happened that affected Lively specifically. She's trying to make it seem, their legal team is trying to make it seem like, oh no, this was to address blatant inappropriate behavior and conduct that was affecting multiple people that were working on the set. Actually, Baldoni's answer kind of clarifies that the document was a contract between It Ends With Us LLC and Blakel Inc. It was designed solely to benefit Blake Lively. It contained these highly individual protections that she had to find all by herself. It gave Blake very broad control over playback, over editing, over simulated sex scenes, over nudity, approving who could view the dailies. It was basically geared towards her. The other thing that she brought up was timing and motive were questions for her, that the agreement was allegedly introduced after Lively was denied access to the rough cuts, and she was pissed off about it. And so she's like, you know what, we got to have this broader discussion. She allegedly waived formal HR complaints in favor of this contract. That was one of the things that I heard. And is that going to affect her complaint going forward? I don't think that it is. She brings up this idea that Lively potentially has waived claims by completing the project without further complaint, and by doing so, framing the agreement as a full resolution. She's claiming that she probably waived the right to sue. I just don't think that's how that's going to come out. They'll probably mention it. If they ever do a 12B6 motion against Lively's complaint, I'm sure they'll bring up those arguments, because what else are you going to do? Why not? At any rate, that was the gist of her argument. So, first of all, you have to understand how employment protections work for employees and independent contractors in California. So, Title VII and California's FEHA provisions, they generally protect employees. They explicitly state the language of which is explicitly for employees and certain other workers that they define. It's not supposed to be for independent contractors, but independent contractors are not truly independent contractors if they are bound by the terms of a contract that makes it look a hell of a lot like they're actually employees. In other words, Blake Lively had bosses. She couldn't come and go as she pleased. She was supposed to be on set. She She was getting a specific wage. There was production schedule she had to abide by. There were probably handbooks and other things that she had to sign that all the other persons on set had to sign as well. She was largely operating as an employee. And guess what? It's not all that uncommon for entertainers to enter into these kinds of agreements and get paid through their loan out, just because for tax purposes, there's benefits to that really for both sides. An employee is circularly defined in California as an individual employed by an employer, obviously. So the titles don't really mean a lot. Entertainers oftentimes provide their services through loan out companies. It's nothing new. It's been going on really for tens of years, dozens of years. I mean, I don't know how far back that would have gone, but they've been doing it really since the inception of Hollywood movies. These loan out companies would pay the entertainers. But courts have consistently held that just because you label a worker an independent contractor or route them through some kind of a personal company, that does not itself strip that person of protections under FEHA and maybe not even under Title VII. If the actual working conditions are such that they reflect an employment relationship. So how do they even determine that? This is kind of the test. If the economic reality and the right to control factors demonstrate that there is an employment relationship, and you see this all the time. If you guys own a small business and you have employees, and it's not, they're coming in to install some drywall or whatever. They're going to come in and do the job and then they're done. They're free to come and go in as they please. They will get there on their schedule, not yours. They will do a job and then they will go. They've contracted to do one specific thing. They finish the job and they're done. All right. Compare that to somebody that, you're going to be here from 8 to 5. You're going to answer the phones. You're going to do this. You're going to do that. You're going to do research. You're going to do, all the things that you would have them do. You'd probably have them sign some tax documents and you could label it independent contractors. But even the IRS knows that, look, so they're there from 8 to 5, Monday to Friday, and they have to go there. They don't have the option to work from home. They don't have, all these other things that would allow them independent control separate from this agreement. Well, then you know what? They're employees, aren't they? And guess what? You owe us employment taxes that you've been failing to withhold from their paychecks for whatever time that you've had them employed as independent contractors. It's really dangerous to do that if you are an employer. So that is an issue. Title VII, under federal law, the courts usually apply a common law agency test. And I'm going to show you guys some of my research that I prepared for today's stream. And this kind of just goes out, and this is taken straight out of Lexis. So Title VII's economic realities test. Under federal law, courts apply a common law agency test. It's sometimes called a hybrid of economic realities and control to decide if a worker is an employee or an independent contractor. The key factors include the hiring party's control over how the work is done, the skill that's required, who provides tools, workplace, the duration of the relationship, how the person is paid, whether the work is part of the hiring party's regular business. No one factor is decisive, but the right of control is paramount. And then there's this case, the Ninth Circuit, Murray versus Principal Financial Group in 2010. They found that an insurance agent was not an employee because she largely controlled the manner and means of her work, indicating true independent contractor status. If she gets to call the shots with the majority of the conditions of her work, and she's there to do a job, and she gets to control how it's done, that's what an independent contractor is supposed to look like. On the other hand, there's this case, Mason versus Helping Our Seniors. A business argued it wasn't subject to Title VII because it was using contractors, but the Fifth Circuit holds that caregivers are employees under a hybrid common law economic realities test. The company hired them, company fires them, sets their schedules, requires training, supervises their performances, etc. So given all of that, those are the ways that they differentiate between independent contractor and employee status. In California, under their FEHA approach, this is instructive because the lawsuit is specifically implicating FEHA protections. They extend to those that are in an employment relationship. It doesn't say employment contract. What they mean is an employment relationship. In other words, no matter what you call yourself, no matter how you've signed the contract, regardless of whether or not you're getting paid out of your loan out company, and your loan out company is listed on the contract. Regardless of even if the contract is even signed. If we could determine from the context of the relationship that Blake Lively is entertainer, she's been hired by the production company to film a movie where she's playing a specific role, where she's on a specific production schedule, where she doesn't get to just come and go as she please, where she doesn't just get to do whatever she wants. Even if she tried to take those liberties during production, the fact that she was writing and demanding that everybody just agree with her terms is evidence that she was herself an employee. They were not just going to let her do whatever she wants. Everybody had to be on board, otherwise it wasn't going to work out. That indicates it's an employee contract. She herself, in her complaint, obviously calls herself an employee because she's seeking the protections. But they extend to those in an employment relationship. That's important, which California defines by, they have their own test, common law Borrello test. Right of control over the work is one of the factors that kind of mirrors Title VII's factors. California's regulations explicitly state that employee excludes bona fide independent contractors. So what does bona fide means? It means like legitimate independent contractors. Like you can't, in other words, hire somebody to install some extra room in the office and just deem them an employee. That is a bona fide independent contractor. They have skills outside of what your company does or produces. They're coming to do a specific job that's not even related to the work that you normally do in the business. You're kind of on their schedule. They tell you when they're available and you say, great, come whenever you're free. And then they do, and then you pay them and then they leave. That is a bona fide independent contractor, not just an independent contractor for tax purposes, such as what Lively would have been with her loan out company. FEHA expressly protects not only employees, but also persons providing services pursuant to a contract from sexual harassment. So in other words, even if an entertainer was deemed an independent contractor, they are still protected from harassment under FEHA's terms. Government Code 12940J1 makes it unlawful for an employer to harass an employee, an applicant, or a person providing services pursuant to a contract because of amongst other things, sex. So even if in the state of California, even if you were a bona fide contractor, you would still have some protections under Government Code 12940 because it explicitly states that persons providing services pursuant to a contract. And then there's all these provisions and reasons why and this and that. This paragraph is very instructive. I've highlighted in red. Under FEHA, an actor who is working through a loan out company can still sue for sexual harassment or retaliation, either by establishing that they were an employee or at minimum that they were a contracted service provider subject to unlawful harassment and retaliations. And that's essentially the heart of Blake Lively's lawsuit. And I'm not even being the bearer of bad news here. Without a crystal ball had a legal theory. Last night, I explained just very haphazardly that it's probably not going to work. It probably just doesn't matter. I'm now showing you the legal reasons why it doesn't matter. But the good news is, if your team Justin Baldoni is, I think the vast majority of you guys are, at least they watch my show, it doesn't mean she's going to win her lawsuit. It just means it's not getting dismissed because of this loan out company theory. Anyway, how do loan outs work in Hollywood? It's common for actors, directors, other creatives to render services via loan out company. So the production company signs a contract with the loan out, Blakel Inc, for Blake Lively services, and the loan out then lends their individual services And that's usually done because of tax reasons. So, you sign your contract with the movie company. The movie company then pays your loan out company. And then for accounting purposes, the loan out company then pays out the entertainer. And then there's tax benefits to both sides as a result of that. So courts have indicated that the substance of the relationship is what prevails over any perceived titles or otherwise. Just because you call yourself something doesn't mean that you're not still, by virtue of the substance of the relationship, an actual employee that is subject to the protections, perhaps under Title VII, probably under Title VII, but definitely under FEHA in California. That's how it works. If the company exercises significant control over the entertainer's work, as Wayfarer Studios did, because Lively could not have done any of the things that she even proposed to do without Wayfarer signing off on it. Treats them as part of the team, as Lively was. The work is integral to the business, which it invariably is. The film needs its lead actor. And I even talked about that somewhat yesterday. It's like, look, we're this late into production. She's giving Wayfarer this 17-point list that needs to be addressed. She's threatening not to come back to production unless it's addressed. They're already at the late stages of production. They can't just go hire another worker to reshoot all the things that they've already shot because it's going to cost them millions of dollars to do that. Better to just finish the film. And so, what is this part? So they were bound to Lively regardless of whether or not they wanted to be. I mean, if they were going to get rid of Lively, the time to have done that would have been at the very beginning of the production stage. And even then, they spent like months, her and Lively, or Lively and Baldoni spent months like building a rapport, building chemistry or whatever. At the first sign where she objected to what her character was going to be dressing as or certain wardrobe decisions, that would have been the time. It's like, look, we're going to enforce what we had already signed up to do. The budget is only this. I can't go out and increase it by $5,000 because you have a creative difference. This is what the film is. And at that point, Lively would have been forced to make a decision. I'm either going to stick with the film or I'm not. But they decided to let her make these changes, and then it kind of snowballed into everything that it snowballed into, where we are now at the point where this has become probably the second biggest Hollywood scandal, trial, litigation of the century so far. So I underlined this part. I thought it was important. The actor is economically dependent on the job for the duration of the project. These are just the factors. You can't simply send a substitute to choose to work their own way. They must collaborate on the production's terms. The courts have been receptive to finding employment relationships in such context, loan out or not. So there was all of that. Let me get to some of this stuff. Jay says, whether she ended up paying herself the flow of funds shows that she was paid or was enriched by production for services rendered, as herself being a specific employee of the studio during filming time. Yeah. How does the independent contract thing even factor into the lawsuit? Well, it doesn't really. She is suing for causes of action that are related to employee-employer relationship. The fact that she might have been an independent contractor, the thought was that perhaps that invalidates her lawsuit because she wasn't an employee. She was an independent contractor. But California law is like, no, nonsense. We're going to look at the context of the relationship. She was an employee of Wayfarer, essentially. Whether or not she signed contracts or not, whether or not she signed through her loan out company or not, the nature of the relationship was she was the actress that was employed by Wayfarer Studios to play a role in the production of the film. She couldn't just come and go as she pleased. And so therefore, in the eyes of the law, especially in the state of California and perhaps under Title VII, she is an employee. So the independent contractor thing matters because if she was actually an independent contractor, then perhaps she wouldn't be able to bring those causes of action. But it looks like the law is basically stating, and I'm telling you that that's basically how it's going to play out. They're going to look at her as an employee. 100% there are. They've already litigated cases like this, specifically in Hollywood. And I'm going to get to some of those right now. So there's a couple of cases. Merida versus Outback Pictures. It's a California Court App 2011. This was a case. It involved a personal assistant on the set of Superman Returns who sued for sexual harassment by the producer John Peters. I don't even know if you guys remember that movie. Anyway, Peters was working on the film on account of his loan out company, JP Organization. He was under an agreement labeling JP Organization as his employer. It's basically the same way that Lively is doing it. And the production entity Outback as the producer. Producer was paying his employer, JP Organization, who was paying the actor, John Peters. The assistant, Merida, argued that she was effectively employed by all three, Peters, his company, and Outback. Outback moves for a summary judgment, claiming that neither Merida nor Peters were Outback's employees because it was a loan out deal. It was for tax purposes. Peters was essentially an employee of them. He was not an employer of anybody. The court disagreed because it found that it was a triable issue of fact whether or not Merida was Outback's employee, despite the formalities. Why does it matter? Because it did not dismiss the complaint. Because even if the court thinks that it's an issue, they're going to, similar to 47.1, how there's a lot of tribal issues with respect to 47.1, if it is raised at all, it's going to be a tribal issue whether or not Blake Lively is actually an employee or if she is an independent contractor, and whether or not the court's going to have to make certain decisions about whether or not that invalidates some of her causes of action. In other words, the court's not going to dismiss on a FEHA claim just because you think that it should be because of independent contractor status. That's what we learned from Merida. At the very least, it's not getting dismissed. Lively is working on a production through intertwined entities, through herself, through her loan out company, through Wayfarer Studios, and all the rest of it. Merida suggests, the case Merida suggests, that Lively can be considered an employee because of the working relationship, and they've already set precedent, or at least an agent under the production's control, even though her paychecks came from Blakel Inc. Doesn't matter. It doesn't matter. The contextual relationship controls everything. The contextual relationship means that California is going to deem her as an employee unless some really weird, strange twist comes into evidence through discovery, which I just don't foresee that coming. There's another case. Robert De Niro was involved in a lawsuit back in 2021. He had a loan out company. He says it was called Canal Productions. So he was being sued by his longtime executive assistant, Graham Chase Robinson, for sex discrimination and retaliation. Robert De Niro was also named as an individual in that lawsuit. De Niro argues, among other things, that Robinson had no claim against him personally. He had tried procedural tactics to try to get the thing dismissed, but he didn't succeed in barring her Title VII claims on the theory that she wasn't an employee. So Robinson had been a salaried VP at Canal for like 11 years prior to that, at the time that she had filed her lawsuit. So what she essentially asserts was she was an employee of the loan out company for like 11 years. And this is a little bit different because the loan out company was being sued as an employer. What that means is if it's covered under Title VII protections, they have a duty to do certain things, as you're going to see in this Lively case. Wayfarer Studios had a duty to investigate claims of SH. similar to what happened in the De Niro case. They were required by virtue of Title VII protections to guard against claims of SH. Robinson says, I've been a salaried employee at Canal for like 11 years. Obviously, I'm an employee of the loan out company. The court proceeds to treat Canal as the employer. That was De Niro's loan out for Title VII purposes. Even though De Niro himself was technically contracted to his film projects via Canal, that did not prevent his company from being sued as an employer. Similarly, it's not going to prevent Blake Lively from filing her lawsuit as an employee of Wayfarer. So it's interesting because this loan out company, in this capacity, not only does it not defeat claims where employee or Blake Lively or people that are utilizing the loan out company for tax purposes, not only does it not defeat their claims when they claim that they were an employee of the studios, but it doesn't even defeat the claim where Lively couldn't potentially be sued as an employer for anybody that was deemed an employee of her loan out company. It kind of works both ways, which is a really interesting way to handle it. So Lively was the employee of her own loan out. But for her claim against the production companies, she has to show that they functioned as her special employers, which they've always looked at it that way. The Robinson case shows us that we've discussed that the courts can parse these relationships and dig into the context of the relationships and look at historically how entertainers have entered into these relationships by virtue of these loan out companies and distinguish between loan out company and entertainer and the potential people that may be employed by the loan out company and the employer who's paying the loan out company directly. There's employer-employee relationships with all of it. No matter what you title yourself, in California law, in the context of the relationship, it's really smart insofar as it will determine on a case-by-case basis whether or not you're an employer or not. More importantly, they're not going to dismiss on those claims if they determine that it's a triable issue, whether or not you were an employer or an employee or an independent contractor or a loan out company or otherwise. In other words, Lively's case is not going to get dismissed on those grounds. I know that nobody has tried so far to dismiss on those grounds. I think that it's been alluded to in some of the amended complaints that have been filed, if I remember correctly. I don't know specifically where it said that. But it's not getting dismissed on those grounds is the point. I don't even think you could get rid of those claims via summary judgment because it's a triable issue. You have to look at the evidence. You have to ferret out the relationships. And that's just how it is. Robinson, that case survived summary judgment and went specifically to trial because there was tribal issues in that case. There's another case in 2019 in the Southern District of New York, no less, Glazer versus Upright. That was a case, it involved performers at a comedy troupe who had alleged harassment. The court had distilled the test for employment status as requiring that the putative employer both compensate and control the worker's performance. And in Glazer, certain comedians were found not to be employees because they weren't paid. And the trope did not direct the manner of their performances in an employer-employee way. And that's not a California case, but if an entertainer is truly not compensated or controlled by the entity, there are cases where Title VII won't apply. In other words, if Blake Lively was not getting paid through her loan out company, if Wayfarer was not paying her loan out company directly for the purposes of paying Blake Lively, then there's a chance that she could have been called an independent contractor. It just wasn't the case. It's not been the case. It's never been the case. And so it's not really a thing here. Lively's circumstances, she was highly compensated. through her loan out agreement. She was subject to significant control on set, in spite of the fact that she was difficult and was constantly trying to make changes to the rules about how production was handled and how things were handled on sets. She had specifically needed to get permission or the okay or the go ahead from other entities if her proposed changes were to go forward. It just makes her, there's no scenario where she's not going to be deemed an employee for FEHA Title VII purposes. I just don't see it. I don't see it. There's another case, Mason versus Helping Our Seniors. It was a 2023 case. It just came out, a couple of years ago. It discussed a recent appellate decision. It didn't deal with entertainers, but it shows that a court is looking at a non-traditional work arrangement and unequivocally saying that if they look like employees under a control and dependence analysis, then they're going to be employees for Title VII purposes. They're going to be protected under Title VII. It's well established how loan out companies work with entertainers in Hollywood. I just don't see it being an impediment to Lively's lawsuit. Other things might work against her, for sure. We talked about all of those things yesterday. But just on the strict basis that she is utilized a loan out company, no, that's not going to be the death knell to her lawsuits. There was another case, Raines versus U.S. HealthWorks. So that case, California Supreme Court holds that an outside business entity acting as an employer's agent can be held directly liable under FEHA for discrimination in hiring procedures. So if an employer delegates certain employment tasks to a third-party company, that company can be considered an employer for FEHA purposes, sort of like what happened to De Niro. In Lively's context, you might argue that Wayfarer Studios and its film LLC were acting as employer in directing and controlling the work environment. Lively's certainly stating that, even though the contract was through Blakel Inc. You could also say that Blake was an agent furnishing Lively's services to Wayfarer. Either way, they were paying the loan out. The loan out was paying Blake Lively. Therefore, parsing out those relationships, that is an employer-employee relationship, unless there's something weird that comes out in discovery where it wasn't. And I don't know. I don't even know what that would be. So the courts have not, so far anyway. And when I say so far, we have like almost 100 years of litigation on the issue. They have, since 1964. Courts have not carved out an exception under Title VII or California's FEHA laws just because a plaintiff used a loan out corporation. They almost don't even care. They really just don't care. That's just the same analysis as employee versus independent contractor. We have rules for that. It's been well litigated for a really long time. We're not fooling anybody with those arguments. Most often, an actor on set will meet the criteria of an employee just because they can't dictate when they get to show up to work. They don't get to dictate the production schedules. They don't get to do a lot of things. In Lively's case, specifically in her amended complaint, she alleges that she was specifically an employee under Title VII. Of course, she had to allege that, right? And that the production entities were her employers or joint employers, and she lists all of them. And she lists all of that for the very explicit purpose, because if they are her employers under the eyes of Title VII, under FEHA provisions, then it requires them as her employers to investigate her SH claims, whether or not it occurred in that 17-point letter, whether it occurred by formal complaint or informal complaint, as we're going to see in a little bit. She cites that there was the existence of the actor loan out agreement with terms that were prohibiting harassment, signaling that even contractually, the producers had assumed obligations that would have been consistent with Title VII, with FEHA, with probably even SAG, and a lot of all of these other conditions. And that's really important. The workplace policies for reporting. Now, look, she is alleging that Wayfarer and all of these entities failed to provide protections to her, or at least give her the opportunity to report harassment. If an employee never reports harassment through available channels, is it possible that an employer might escape culpability in that case by showing that it could have been remedied if the situation was known? That's been used as a defense before, but it doesn't apply if the harassment culminated in a tangible adverse action. And in Lively's case, she alleges that the retaliation that effectively ended her involvement with the production company, with the project, has harmed her career. She's saying all these things. That is a tangible action that implicates them. She has to argue it that way because she's claiming Title VII protections and FEHA and all these other things. It's a specific provision that coincides with her First Amendment complaint, which is why she has argued it the way that she has. She did complain informally. She said that she had tried to handle matters discreetly. Remember that in her amended complaint? She said that she and a female co-star that is yet to be named had commiserated about Baldoni and Heath's inappropriate on-set behavior. I think that she had mentioned that they had talked about how nobody has to hug anybody anymore, and that the other lady on set was like, "Oh, thank God," or she expressed some kind of relief. They had talked about Baldoni and Heath's inappropriateness on set. Lively expressed gratitude that the colleague had spoken up, that noting that she felt untethered. She used that word, untethered. And the colleague's support helped to ground her. More significantly, Lively says that she attempted to privately resolve concerns of misconduct and sexual harassment by going specifically to the HR department, but they were controlled by Baldoni and Heath, and so it was problematic. Wayfarer's response essentially was to fail to investigate those concerns. She says that, look, we have channels for that, and you got to go through the proper channels. She never went through the proper channels. I guess her argument is that she wasn't provided proper channels. I don't know. But she specifically argues those things because of the Title VII stuff. Did she waive formal complaints or settlement? I've heard it suggested that she had waived her access to formal complaints because she never actually filed a formal complaint, or perhaps never filed a formal complaint. If an employee explicitly agrees not to file a complaint, that's usually not something that you could contract for. In other words, it's really hard to waive certain constitutionally protected protections. In other words, imagine signing a contract where it's like, look, we're going to just resolve this discreetly, whatever, but you have to agree to certain things. But in exchange for that, you cannot go and make complaints for sexual harassment or whatever. Let's just say that that's what you want to contract for. I don't think you can legally just do that. You could have an agreement that tries to do that, but if you try to raise that issue under Title VII, and then they try to cite that, well, we agree that we're going to make these things in complaint, they're going to say that you can't just waive Title VII FEHA rights in advance. You just can't do that. It's severely against public policy. I mean, you could have like a post-incident thing that happens. But in other words, let's just say that Blake Lively goes and she raises this issue about the 17 protections thing or whatever it was, and these behaviors that make her uncomfortable. And then the studio goes and says, all right, fine. We will make these accommodations for you, but you cannot afterwards go and, claim SH because of whatever. You have to agree not to do that. If we're going to make these accommodations, whatever, fine. You can't do that. What you can do is, after it has happened, obviously you could enter into settlement talks and have NDA agreements and all those kinds of things. You can do that kind of stuff. It's just not the same thing. I don't think that she's waived any protections under anything for failing to make a formal HR complaint. I don't see that being a thing with this case. I think that pretty much covers the loan out issue. Am I missing anything? I've not been looking at your guys' comments. Let me see what you guys are talking about over here. Someone in the chat stated that Blake did not file with the EEOC. I've heard that before. I guess the short answer to that is, under California law, the argument that Lively's CRD complaint is somehow invalid because she contracted through a loan out company is unlikely to see. Number one, that's not going to happen. But the formality, I think you're asking about the formality. Was it procedurally defective? Generally, no. Generally, California law is pretty forgiving about that. If there's some, I don't even know what the procedural defect would be. EEOC, I don't know. I don't think that it would matter. I'm just honestly, if she didn't file with the EEOC, I haven't heard anything like that. I haven't argued that it's procedurally defective. I don't believe that that's going to be fatal to her complaint if it is. She did file a CRD complaint. That's usually enough. She did get a right to sue letter. As I recall, didn't she get a right to sue letter? I'm pretty sure that she did. Like way back at her initial complaint. Am I wrong on that? I want to say that in the very early stages when she filed her CRD complaint, she obtained a right to sue letter. I sort of remember somebody stating that she didn't get a right to sue or something like that. Am I wrong? Am I mistaken? I feel like she did. I'm not sure. Let me look through this complaint. I feel like they have. Yeah. I don't know. I don't see it readily available in my notes about whether or not she got that right to sue letter. I don't remember if she did or not. I feel like she has. I've been hearing like chirps about maybe she hasn't. Well, no, I can't find it. Jules says, yes, she did. If Jules says it, then it must be true. Yeah, I thought I saw it. She got a right to sue letter. If she got the right to sue letter, then that's kind of game over for that. Then whatever defects, there's not any defects in her complaint as far as I can tell. Unless I'm wrong, I don't believe that there's any defects in her filing of the CRD. She went through that whole process. She got a right to sue letter. There's not any procedural defects that are readily apparent to me. The one issue was the loan out issue. The loan out issue to me is resolved by California's long history of ferreting out employee independent contractor relationships through a case-by-case basis. And so there's that. Samantha Glover says she did, but that is from CRD. She asked for an immediate right to sue letter. I don't know what happened to that. I don't know. Did she get it? I don't know. I guess she did. Everybody's saying that she did. If she's missing something, somebody's gonna let me know about it in the comments, or maybe perhaps somewhere else. I don't know. She needed to file with CRD to sue individuals. EEOC only allows for organizations to be sued. Yeah. Well, folks, that's all I got on the loan out issue. I will maybe be streaming something later tonight. Some of you guys have been asking me what's going on with Lauren Knighty. She's on vacation with her mom. It's what I've gathered from her, but she's safe. She's safe and she's doing well. At some point, me and her are going to do another live stream together. I don't know when that's going to be, but she took a little small break. People were worried about her, but she's doing just fine. For the rest of you folks, I love you guys. That's all I got for you today. I will see you guys maybe tonight. If not, then for sure, definitely tomorrow. Love you.